State of Wisconsin versus Lee Moritz. I just noticed your shiner.
Yeah.
What happened?
Had an accident at home. Fell off a ladder.
That looks pretty bad.
Yeah, it's not good. It doesn't feel good.
Ouch.
I have written pages of my life and incidents with Mr. Moritz, and there was one statement they all had in common. He knew exactly what he was doing. Mr. Moritz knew exactly what he was doing every time he violated the restraining order. He lied and manipulated situations to avoid responsibility. He knew from the beginning he had a restraining order. I told him I was getting a restraining order for trespassing on my grandmother's property and taking my car from me. After that, he texted me to drive the only thing in my name to work tomorrow, leaving me my gas golf cart. But he didn't seem to care because his response was, do whatever you have to do. He threatened me to drop the charges, telling me how small I am and what he can do when he's sober. He purposely avoided police for 8 months and continued to harass me. During this time, I felt unprotected by calling into the sheriff's department. The first time I called, the deputy that I got asked me, have you just tried blocking him? And the text messages that I sent to the deputy never made it to the DA's office. The victim witness coordinator told me there was a possibility of closing the case due to the missing documentation of the text messages. Mr. Moritz also told me his sister, who is a police officer, notifies him every time I call him in, and that he is above the law because of this. Whether this statement is true or not, I do not know, but I can say that there was information Mr. Moritz and his sister both knew about when I spoke to other police officers and jailers. One of the times Mr. Moritz was brought into jail. Along with Mr. Moritz's blatant disregard of the law, he also has a terrible drinking problem. Mr. Moritz buys a case of beer every day or every other day, as he puts it, when they're good days. He also says his doctor told him drinking his beer was just as good for him as any other option. I would be surprised if he blew a .0 here today. If you notice on the text messages submitted and other documents, most of the time Mr. Moritz starts harassing, threatening, and abusing around 4 p.m. He's had then hours of drinking in, and depending on his schedule, there are times when he doesn't sleep and drinks all night long and makes the situation even scarier. He often insulted me and humiliated me, especially about my body. He would tell me things like, "You're disgusting," and told me he would only listen to me or seek help for his drinking if I maintained a certain weight. He often called me worthless and a cunt, and I could be replaced at any time. These were things he said in front of the children, teaching them to be disrespectful to me too. This happened regularly, and after arguments, he would deny or say I was too sensitive and that I shouldn't take what he does or says after a night of drinking too seriously. Tomorrow's a new day and you need to move on from it. He also told me in front of my son that it would only take $10,000 to have me killed. These threats and cruel statements happened many times over the years. There were physical incidents that happened, including throwing wood at his son and grabbing him by the throat. This behavior led to a CPS case in 2023, and instead of taking responsibility, he blamed me and the children. He forced me out of our home on dozens of occasions, dragged me out of bed, locking me outside with no place to go. One time he dragged me out of the house by my ankles and locked me out. But then he called me the next morning when I wasn't home, asking me when I was coming home because he was horny. Another time, he threw a tray of grease and fat at me and my son when we tried leaving, hitting us in the car. He's had his hands around my neck, pinned me in corners, threw my phone in the toilet and peed on it so I couldn't contact anyone. And at these times, I had to fight back to protect myself. When I did fight back, Mr. Moritz would tell me would tell people, family and friends, he didn't do anything, and I just went crazy on him for no reason. When I was able to leave and get away from him, he would follow me in vehicles. He would show up where I was, follow me to stores and my family's homes. The times I could not leave were because he would hide my keys or even drive my car into deep snow so I couldn't move it. Financially, Mr. Moritz has abused me by taking my car from me without permission, leaving me without a vehicle and no other access to the vehicles in both of our names. He told me I didn't pay for shit during our relationship and I didn't deserve anything, which is not the case. Mr. Moritz also tried to buy propane under my credit card in January 2026. When I called and asked Northwoods Propane about the incident, she immediately apologized and said, "I'm so sorry. This is a card he said it was okay to charge to, but I'm returning your money immediately." This might be Mr. Moritz's first time with charges, but he is not a first-time offender. Mr. Moritz has multiple CPS cases from his children, a couple of closed cases with his adult children, one closed case with my son in 2021. I would go even further to call him dangerous. He knows exactly how to act, in front of who and when. His thought process and how he believes and perceives the world is scary. He told me more than once that I deserved my abuse, and the only reason I can get him in trouble for what he does is because I have a vagina. His children deserve their abuse. But he did not refer to it as abuse when he was speaking about me and his children. In his mind, he was defending himself, proving a point, or his actions were just everyday life. He always states he never does anything wrong. Mr. Moritz once told me he was like a god and should be treated as such. And I should be washing with his feet with my hair like Jesus instead of running my fucking mouth. He also told me once he was born in the wrong generation. He should have been born back when it was acceptable to lock up your wives for disobeying. Since I moved from his home more than once, Mr. Moritz has tried to portray on social media and in text messages that I have been with him. He will post pictures on Facebook and send me random text messages stating, "If you're still here, will you feed the dog? Would like to request 60 days upfront jail time and 1 year of probation. Thank you for your time and consideration."
Moritz, do you share a child with BJR?
No.
No, okay, so,
I raised her son since he
okay.
was 5.
And is that the document your attorney went over with you?
Yes.
Did he go over it thoroughly with you?
Well, as much as I can understand. It's all gibberish to me.
Well, as much as you can understand. So did and I'm gonna guess that you had questions for your attorney and you said, "I don't understand that." When you said those things, did your attorney then explain it to you more?
He did, but
And
in my mind,
Mr. Moritz, I'm stopping this. I'm not gonna let you make statements and say, "I don't understand this, I don't understand this, I don't understand this." Because if you're telling me that, then I'm gonna have to order a competency evaluation, okay? Because I need to make sure that you're competent to enter a plea. You're competent to be here today and to have these charges brought against you. And so if I'm hearing from you that even though you're a learned attorney who's went to law school, who's practiced for many years now, if I'm hearing that he was unable to explain the words on that document to you thoroughly so you can understand.
he did, yes.
He did.
Yes.
So there's no question, you understand everything on that document.
Yes.
Years of schooling do you have? Do you have an HSED, GED?
I graduated high school and I went 2 years to Dakota County Technical College for mechanics and machining.
Excellent. Okay, so you have more than just a high school education.
Yes.
Okay, so you can read, write, you understand the English language, and then did you sign those documents?
Yes, I did.
So you are 50 and you are pleading guilty to 1 count of knowingly violating a domestic abuse order, correct?
Yes.
Are you admitting guilt here today, Mr. Moritz, because you are guilty?
For text messaging, yes.
Yes. I mean, you can try and pass it off any way you wish and try
Yes.
and, you know,
For
pass the buck, but it's,
No, I didn't understand that no contact I thought was physical contact. I didn't understand that text messaging was
all right.
out the
And-
window.
And here's the deal, and I'll swing right around to there, because I want to make sure you understand everything. The arguments made on the record that you were evading service and that they tried all means of service and they had to resort to publication, okay? And so it was published in the Burnett County Sentinel, because you live here in Burnett County and actually you're from the Sentinel area where they publish. And it had notice of that hearing. And you did not appear, but there was the proof of publication and you appeared. And so that injunction with the firearms was entered, correct? Yes.
Yes.
And so then a firearm surrender hearing was then scheduled because the court is mandated to do that. And then service was attempted to be made with that, but then it needed to be published again. You understand that at that hearing too, you failed to appear, correct?
Correct.
And then the court had to issue a warrant because that is mandatory. The court shall hold a firearm surrender hearing and you didn't appear. So the court had to issue a warrant and a warrant was issued. You were picked up on that warrant on May 27, 2025. The court then held that firearm surrender hearing, correct? And you were present.
Yes.
And the court went over all of those things with you, all of the, with regards to the injunction, and you did make and raise arguments at that date and time that you didn't understand, you didn't know you needed to appear, and you didn't know what it meant to have an injunction, correct?
Correct.
And did the court thoroughly go over with you what that all meant?
Yes.
So the court thoroughly went over what you can and cannot do and what it meant, correct?
Correct.
And then what happened occurred on June 13, 2025 after that, correct?
Correct.
All right. So I just wanted to make sure we were all clear. So now, with regards to that, you are pleading guilty because you're guilty, correct?
Yeah, correct. That just sounds really bad, domestic abuse, because I've never abused anybody. But
And you
I did
can-
text. Yes,
You
I
can
did.
argue those things, but the thing is what was entered for that injunction is a domestic abuse injunction,
Yes.
okay? And you knew
Okay.
that, right?
Yeah, I understand now.
Yes. And we went over that back on May 27, 2025, right?
Yes.
Yes. And so now the charge here is that you knowingly violated that injunction order. You understand?
Yes.
And so as to that charge, knowingly violating a domestic abuse injunction order, how do you wish to plead?
Guilty for texting.
Well, you can put the caveat on all you want. I believe you fully and thoroughly understand everything,
I
correct?
understand. Correct.
So now as to that charge, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily.
Now, the state is arguing for a withheld sentence in favor of 1 year probation in this, excuse me, 1 year probation in this matter. This is not a case of a single restraining order violation. Mr. Morris was charged with 3 counts of violating a domestic abuse injunction and 1 count of misdemeanor witness intimidation. Now, while he is taking some responsibility by taking the plea here today, he also appeared before this court back on October 13th of last year and argued that he didn't understand the law. He didn't know what it meant to have a domestic abuse injunction. In fact, one of the bases for the charges is that back in June of 2025, he texted the victim. He said he knew that there was an injunction in place. He knew it meant no contact and that he didn't care. So while he has no criminal history, I believe probation for 1 year is not only appropriate, but necessary to ensure that he does not have contact with the victim, to provide the victim with that added peace of mind, in essence, to specifically deter Mr. Lee Moritz from re-engaging in these problematic behaviors that have led him to this point.
I'm stopping you
Today.
right here. Do you have a traumatic brain injury?
No.
Okay, so you weren't in an accident, didn't hit your head, don't have a traumatic brain injury.
Well, I bumped my head, but
Bumps, yeah. No, were you diagnosed by a
no.
medical doctor?
No.
For a traumatic brain injury? Okay. Learning disabilities?
No.
Okay, I just needed to know that. So I guess there's nothing you need to respond to. Go ahead.
Yes, Your Honor. So again, to specifically deter Mr. Moritz from re-engaging in these problematic behaviors in the future, but also to just generally deter the public that restraining order violations are criminal offenses. They carry penalties and they should be treated accordingly.
He's 50 years old. He does not have any sort of prior record. He owns his own landscaping business. He's a hardworking, productive member of society. I think that reflects well on his character. I will note that there have not been any incidents of contact that I know of since September. He's been following the injunction over the last 7 months. I think that does show that he is able to conform his conduct to the requirements of the law. So, it was a bad breakup after long or 6-year marriage where, essentially he was pleading with her to come back. That's a large part of the text. There's no allegations here of any violence. There's no in-person contact with the text. His sister, Bridget Getz, has already been mentioned, but she's a law enforcement officer in Burnett County. I believe she's in the courtroom for support. I generally, Your Honor, tend to think of probation as really addressing rehabilitative needs or public protection. I don't know that those are really relevant here, at least as to the charges pled. I know there's been a lot of allegations that were made in court, but he doesn't have a record. We do not have a problem if the court wants to hit my client in the pocketbook with a $250 fine to serve as deterrence. but that's what we would ask for, along with court costs. Thank you. That's all I have.
All right, Mr. Rosenthal, before I turn to Mr. Moritz, I want to make sure that you, as his counsel, you've been there throughout these matters with him. Do you believe he has entered a plea freely, knowingly, and voluntarily?
I do, Your Honor, and I understood some of the court's questions about the competency and brain injuries and those sorts of issues, and I am satisfied. I've been doing this a while. I've raised competency issues on a number of other occasions. I don't see those here.
I love that woman, and I just was trying to get things worked out. I made a mistake. I didn't realize the repercussions of texting would go this far. I was just trying to work together so we could figure out our future.
Okay, anything else? That's all?
Well, a lot of half-truths going on here, half-truths, but
From your perspective, I'm here to listen because this is where I make my decision as to what is going to be sentenced.
Bobby Joe
Lee,
was very abusive to me.
I don't know that I want to get into litigating too much of this, Lee. I mean, but Judge is right. I mean, this is your time to talk.
I've been punched and beaten and scratched and scarred from that woman. And I didn't call CPS or call the police because I didn't want her to lose her son's custody.
Is that where you got the shiner?
No, this is a different, I mean, this is a couple years ago.
Okay.
She beat me with an extension cord on my back until I was bleeding and bruised. That's why I locked her outside of the house, because she was violent tendencies. And it was so bad that I couldn't even take my shirt off on the boat for the 4th of July weekend because I didn't want my parents to ask what happened to your back. And there's a lot more examples to that, but I don't want to get there. I don't want to get anybody in trouble. I want peace. That's all I want is peace. That's just one incident, just one. There's many, many more.
Okay.
And she's playing the victim here, and it's half truths, you know. We're both human. It is what it is, but never beat her with an extension cord.
I have the victim go first because then it gives an opportunity for the attorneys as well as you to be able to digest what is being said.
Mm-hmm.
Victim statements are like any other statements of any witness or any individual appearing in front of the court, okay? The court makes a credibility determination based upon what's said. The victim made a statement. Now, do I believe every single statement is 100% accurate? Probably not. But that's because I'm going to tell you, just knowing that sometimes as a person that's going through something, we experience something one way, another person experiences it another way. Any statement or any story somebody gives you is not 100% accurate.
Correct.
Okay? Yes, and you agree with that.
Yes, absolutely.
I know that you knew things and you knew what you could or could not do. You knew what it meant. You knew all of those things on May 27, 2025. And then we have the first allegation, the one you pled to, on June 13, 2025. And then a couple more thereafter. So I knew you knew what you could or could not do. And you're shaking your head up and down and saying yes.
Yes.
You knew. All right.
I knew after the first court hearing that I was not allowed to text.
Right.
And I have not since.
Well, you haven't since at least September 15, 2025.
Yes.
And it was mentioned by somebody here at the hearing or by the victim, and it was mentioned previously at a hearing. And to this court's knowledge, your sister is a law enforcement officer, a respected, experienced law enforcement officer.
Yes.
I respect your sister.
I do too.
Okay. I truly believe you fully understand everything and that you have understood everything.
I do now, yes.
Yes. But I believe you understood prior to today and prior to the last hearing and prior to the other hearing.
Yes.
Yes. Yes. I believe you fully understood everything. I'm going to tell you that you sit there, not only in this hearing, but in other hearings, and you put on a dumb face. And the dumb, yep. And
I'm
the
not
dumb
a lawyer.
words.
I'm not a lawyer. I have never been in trouble with the law. I don't.
Again, not an excuse. And you're saying words to make you seem like, I don't know, I'm just poor poor little old me, I don't know anything. I have a high school education and only 2 years of college with a very smart degree of mechanics, because I know plenty of mechanics, that's a smart degree. You need to be smart.
Right.
Right, you need to be smart. You are not a dumb man.
No, I'm not. I'm very intelligent, but when it comes to this stuff, it's,
Again, credibility. I don't
no,
believe you.
okay? Yeah, I
You
understand.
don't have a TBI, a traumatic brain injury. You don't have a learning disability.
Trying to make peace. That's all I was trying to do.
Yeah, trying to make peace, violating law.
Yes,
Right? Yeah, trying to make peace, violating the law.
yes. Yes.
And today is your day for remorse, and it is your day to clear everything up and to let the court know, well, this may be not the full truth, or this may be something that was said incorrectly. But as you sat there, you're not taking accountability. You just say, it was just text messaging. Okay, that's all I did. I was trying to, make everything better. And
Yes,
yes, and you know that.
I do. Yes.
And you keep interrupting, and that means this is going to be the longer it's going to take. But I don't believe it again. I don't believe it. You fully understood every single thing you were doing, and you continued to violate the law time after time after time after time, and with every excuse. And then you're sitting there not taking accountability, not being responsible, trying to just kind of haphazardly say, well, I was texting and violated. And then you victim blamed. You said it was her, it was her, it was her. She's the one that hurt me. She's the one that beat me. She's the one that did this to me. She's the one. I don't have any alcohol issues. I don't have any drug issues. I don't have any violence issues. I've never engaged in any domestic abuse. I've never done this. I've never done that. It was always her.
I didn't say that.
Then what did you say?
It takes two to tango.
It takes two to tango. Sure does. Can talk to the domestic abuse, domestic violence counselors and all of that, and the lawyers and all of that involved, and the law enforcement officers and all that. It always takes two to tango.
It does.
Does not take two to tango. Does not. Even if she came at you, she whipped you with a extension cord, she beat you over the head with a bottle. Doesn't take two to tango. It takes your two legs to get up, to walk out of that door, and to stop.
I've done it many times.
And then to go deep, deep, deep. 911, what is your emergency?
I didn't want her to
Lee,
lose custody of her
on
son.
advice of counsel, I'm going to ask you to quit interrupting, Judge. Okay.
And I have to say that now too, because we are now at 12:28. This is a half an hour over. But again, I'm not cutting it short because I cannot. That's not my job. My job is to do this thoroughly. I think that this is serious, and I think that you knowingly violated, you knew what you were doing, and I think that deserves punishment. Probation, yeah, sure. What the court is going to do is I will follow a recommendation for probation, because you need oversight. You need somebody to watch over you. You need somebody to make sure that you're not drinking. You need somebody to make sure you're entering in the programs that you need to enter into, and you're doing things knowingly violating the law. So 1 year of probation. I'm going to order, because I think that this is so serious, and I think that you are dodging responsibility and accountability. 45 days of conditional jail to be remanded immediately after today's hearing, because it is that serious. I saw no accountability. I heard no remorse. I just saw the, I'm rubber, you're glue, I'm the eraser, and it bounces off of me and sticks to you kind of deal.
It's not like that.
But that's what it's coming across as, okay?
But it's not like that, Your Honor.
Okay, I hear you. But that's the court's order. On probation, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol, regular drug testing, substance testing, regular alcohol testing, immediate alcohol testing upon remand to the jail. No contact with the victim's family. I'm going to order a domestic violence program, AODA assessment and follow through, $443 in fines and fees. Payments will be at least $50 a month. Failing to pay not only means the court will enter a civil judgment against you, you're always going to owe it, but the court will issue a warrant. You could most likely sit jail as a sanction for failing to pay. I'm going to be very clear with you. You could sit up to 6 months in jail for fail to pay. If you cannot afford to pay, you must have a hearing with me. I'm also going to order a total 9 months imposed but stayed sentence. If we're not missing anything, we are adjourned.
Here's where the hearing takes a dramatic turn. Instead of focusing only on the injunction violation, Mr. Moritz starts presenting himself as a victim inside the relationship, describing alleged violence and emotional abuse against him. But notice the judge's reaction. The court is not retrying the entire relationship today. It is evaluating accountability for violating the order. That distinction matters legally. Do you think these statements sound like genuine context, or an attempt to redirect responsibility away from the charges? The judge is now zeroing in on credibility, and this may be the most important moment of the entire hearing. Watch how every interruption from Mr. Moritz seems to deepen the court's frustration. In sentencing hearings, judges often look less at excuses and more at accountability, remorse, and future risk. That is why the repeated "I was just texting" argument is landing so badly here. Serious question for viewers. Should repeated restraining order violations lead to jail time, even without violence? The judge ultimately sided with the prosecution's concerns, ordering 1 year of probation, strict sobriety conditions, treatment programs, financial penalties, and 45 days of conditional jail time. What really drove this sentence was the court's belief that Mr. Moritz minimized his actions and avoided accountability throughout the hearing. If you found this case as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more courtroom breakdowns.